We'll start at 1 past. Okay, I think we have a lot of participants already with us, so I would say we could start. Welcome everyone to today's webinar on leading strategic litigation cases against torture. I'm Alejandra Vicente. I'm head of law at Redress, and we are delighted to have you with us today. I'm going to start with a few housekeeping rules. We have simultaneous interpretation in today's event, and this is available in Spanish, French, and Ukrainian. You can activate this feature at the bottom of your screen by selecting your preferred language. As participants, you will not be able to use the microphone today, but you can find a Q&A, a question and answer chat box again at the bottom of your screen, and please feel free to send your questions, your comments at any time during the session. If possible, include your name and the organization you work with, and we will collect all the questions as they come in. We will group them as needed, and we will address them during the Q&A segment of the event. Well, this webinar is part of Redress's Solidarity Program, which aims to promote the exchange of experiences on strategic litigation, strengthen the global anti-torture movement, and contribute to a growing community of practice. In today's event, we want to examine how strategic litigation can serve as a powerful tool in the fight against torture. And we will do this by discussing 3 emblematic cases from various human rights systems that have contributed to shaping domestic, regional, and international legal standards on the prohibition of torture. Our distinguished panelists will not only share insights into the litigation processes behind these cases, but also reflect on the broader impact of their work and the future of the anti-torture movement, particularly in light of current global challenges. The 3 cases that I mentioned are, first of all, Velasquez Rodriguez versus Honduras. This is the first and one of the most frequently cited decisions of the Inter-American Court of Human Rights. It addresses practices of torture and enforced disappearances during the Honduran dictatorship, and it laid foundational principles on accountability for the Latin American region and beyond. The second case is La Cantuta versus Peru, concerning the enforced disappearance and killing of 9 students and a professor during the Peruvian armed conflict in the 90s. And this case was key in advancing accountability and combating impunity, particularly through the use of amnesty laws. The case set standards which are cited over and over again in international and national jurisdictions. The third case is Khashiyev and Akayeva versus Russia, and this is a landmark ruling of the European Court of Human Rights on the torture and killing of several relatives of the applicants during Russian military operations in Chechnya. This case sets a precedent for thousands of similar cases concerning violations of the right to life and enforced disappearance, including the lack of investigation for allegations of torture. The 3 cases are included in Redress Casebook on leading strategic litigation cases against torture. where we discussed 23 cases which are emblematic against torture across the globe. Cases in which strategic litigation was used and that serve as good examples of the potential of creative litigation to transform the law and practices. Of course, the publication is not exhaustive. We should have included many more cases, but still it could be of use for many practitioners. Hopefully many practitioners also participating in today's event who are litigating similar cases or where similar legal issues are coming up. With this, I would like to introduce our panel of experts who are also very dear friends of Redress. I would like to start with Viviana Krsticevic, who is a distinguished human rights lawyer with a degree from the University of Buenos Aires, an MA in Latin American Studies from Stanford, and an LLM from Harvard Law School. She currently leads the Center for Justice and International Law, where she has developed extensive litigation experience leading to transformative change across the Americas. She's also the co-founder of the Equal campaign, and her contributions include the development of the Esperanza Protocol on the protection of human rights defenders against threats, and the promotion of an advisory opinion from the Inter-American Court on Human Rights on Climate Emergency, which actually just came out a few days ago. Viviana also serves as an expert on the UN fact-finding mission on the Islamic Republic of Iran for the Human Rights Council. This year, she received the Prominent Woman in International Law Award from the American Society of International Law. And Viviana today will share her reflections and experience related to the case of La Cantuta versus Peru, which she co-litigated at CEJIL. Our second panelist is Juan Mendez. Juan is a recognized Argentine human rights lawyer and a former United Nations Special Rapporteur on torture. He's currently professor of human rights law in residence at American University Washington College of Law, and previously served as special advisor on crime prevention to the prosecutor of the International Criminal Court. He was the president of the International Center for Transitional Justice and also worked for over 15 years at Human Rights Watch, focusing on human rights issues in the Americas. And today, Juan will share with us the experience on the case Velasquez Rodriguez versus Honduras. Our third panelist is Elba Bendo. Elba is a human rights lawyer specializing in enforced disappearances, equality, and non-discrimination law. She currently serves as an international advocacy lawyer at the European Human Rights Advocacy Center, EHRAC, where she collaborates with regional partners in Eastern Europe and the Caucasus to bring cases involving serious human rights violations by security forces before the European Court of Human Rights and United Nations human rights mechanisms. Over the past 5 years, Elba has led EHRAC's efforts on the implementation of the Khashiyev and Akayeva group of judgments. So with this, I would love to start today's discussion. And I'm going to ask a few questions, the same question to the three of you, and you will have 5 minutes each to respond. So my first question is, and perhaps I'm going to start with Viviana, Juan, and Elba for this first question. The question is, from a strategic litigation perspective, what were the obstacles to litigate your respective cases? And how did you address them? And also, what do you think was the key element in your case that should continue to inform current and future efforts to litigate torture cases? Viviana, I'm going to give you the floor first. Thank you.
Thank you so much, Alejandra. It is truly a pleasure to participate in this panel and to continue contributing to the fight against torture. I would like to start my reflections on the obstacles, addressing something that many people that are doing litigation in international fora know, which is that time sometimes is not our friend, and we have to deal with long processes of litigation, sometimes in hostile, risky, or contexts where the claims for truth and justice and against torture are unpopular, and that those contexts change over time. Coupled with that is the fact that you are sometimes, especially in the case of Cantuta, we were dealing with a group of victims and family members of victims, which compounds the challenge of dealing with people that are undergoing trauma in a hostile environment over time, over many years. And sometimes these patterns, these violations of human rights, and the fact that the people that we represent had been tortured is not an isolated event. It's part of patterns of violations and lack of accountability for gross violations that is entrenched in the letter of the law, sometimes domestically, and these patterns and these legal obstacles that we face, and sometimes the factual obstacles that we face, have not had necessarily an adequate response in the development of the law internationally. So in dealing with some of these issues, I have to say that in the Cantuta case, we went through several governments in litigating the case, and in a situation of hostility, and then more accompaniment of the family members by big sectors of society, to, again, situations of a lot of hostility towards the family members and the search for truth, justice, and accountability in Peru. And a key aspect of responding to that over time, and a key part of the strategy of litigating on torture and accountability, was keeping a victim-centered approach to the litigation, caring about individual victims, but also of the cohesion of the group of victims, creating the support and the links with other groups of victims that were in similar situations, that accompanied each other over these processes. And that was not by the virtue of what we did as lawyers, but of the smarts and the wisdom of the human rights community and the victims themselves in Peru. So this was a very important part of carrying on such a difficult quest for truth and justice over the years. It was a search that was a search for truth and justice that is only explained with a lot of love and persistence in trying to find the whereabouts of the family members. And then on the second aspect, on the factual and legal developments that represented obstacles that were many, including the amnesty laws, including the fact that President Fujimori was out of the country when we were litigating the case of Cantuta at a critical juncture. One of the important aspects of litigation was that we litigated thinking about how the laws and the jurisprudence has had to evolve to seize the facts. So the idea that the standards on accountability had to be transformed to be effective in their response to the needs of justice was critical. In the case of the then future extradition of President Fujimori, but also in the way in which the wording of the search for justice was phrased in the initial decision on Barrios Altos and Cantuta, on how the amnesty laws had to be considered without effect. And subsequently, in different stages of the litigation after the judgment and in the supervision of the compliance with the judgment, we kept that philosophy very close to our hearts, which is helping the legal developments respond to the search of for justice and truth, including with issues of pardons and other obstacles to repairing the rights of the family members of the students of La Cantuta and the professor.
Thank you. Thanks very much, Viviana. What do you think, Juan? What are your reflections on this first question on obstacles and key elements?
Yeah, thank you very much, Alejandra. I especially want to thank Alejandra and Redress for the opportunity to discuss these very important lessons that we can, disseminate from these three cases. In the case of Velasquez Rodriguez, I need to refer back to the fact that these cases are from 1980s, at a time when disappearances was a huge scourge in many Latin American countries, but that was not adequately treated in the treaty law, or even there was not much jurisprudence about it. Also, that the Inter-American Court was a brand new court. It was hearing for the first time what they called contested cases, adversarial cases. The language that the court uses is contentious, but that's a bad translation for Spanish, actually. Before that, the court had issued several advisory opinions, but this was the first case in which a state defended itself from an accusation of violations of the human rights contained in the American Convention on Human Rights. And we didn't have any track record, any way of knowing, either substantively or procedurally, how the court would deal with this. And we also felt that disappearances particularly was one of those almost perfect crimes, because the whole idea of disappearances is to hide the fact of the disappearances and the evidence of the disappearance. And so we were confronted with a case that had been litigated for some years in the Inter-American Commission, but the Commission had not built much of a record on it. And so we needed to go to the court with a very thin documentary record and very little evidence. But at that time, I was with Human Rights Watch, and Human Rights Watch had a very strong presence in Central America, including a permanent office there. And so we had a lot of contact with evidence, with witnesses, with organizations defending human rights, and also with relatives of victims of human rights violations. And so we built a case around the need to show that the case of Ángel Manfredo Velasquez was part of a pattern of governmental repression that was directed and created from the higher echelons of the army of Honduras. And of course, it included descriptions of torture, because torture was used extensively, mostly in the case of Honduras, to break up networks of support for guerrilla movements in El Salvador and Guatemala, but not so much to use violence within Honduras. And what we did was to try, and we convinced the commission first, because the commission was the litigant there. We were just supporters. Again, this is something that changed over the years, but we represented the victims, but we were really adjunct advisors to the Inter-American Commission. So we persuaded the commission and then the court to hear evidence not directly related to the events that caused the disappearance of Ángel Malfredo Velasquez, but about other disappeared. And even we had witnesses that had survived the experience and testified in court about where they had been taken and how they had been treated. And we even had defectors from the security forces that testified to the use of clandestine detention centers, to the use of torture, and to the elimination of some of the people who were the victims of disappearances. So all of that created evidence of a pattern that the government representatives were not very able to destroy in terms of evidence. So they tried their best, but quite frankly, the evidence became pretty overwhelming. So I have to credit first the relatives. The relatives were a very important way for us to. They testified themselves as to how the families had suffered disappearances of their loved ones, but they also put us in touch with other people who could help, create an evidentiary basis. Second, I have to credit the court. The court was incredibly open-minded and welcoming of this kind of evidence of an evidentiary pattern, rather than keeping us focused on how and where Velasquez had disappeared. But most importantly, in the decision, the court did a wonderful job of describing the phenomenon of disappearances in a way that is exemplary. As you said yourself, Alejandra, this case has been mentioned over and over again, because it not only described the factual circumstances that constituted a pattern of disappearances, of which the disappearance of Ángel Manfredo Velasquez was only one case over maybe 200 similar cases in a period of a couple of years. But they also described the phenomenon of disappearances and established the legal consequences of disappearances in the fact of calling them a crime against humanity. And because they're a crime against humanity, they engage the obligation to provide for accountability. And although, fortunately, in the case of Honduras, there was no issue of amnesties or any other legal obstacles, but of course there were factual obstacles, including the way Honduras treated the habeas corpus writ. That was ridiculously ineffective. I mean, you actually had to say to the court, my client has been detained, and he's detained here and there, and with a precise location. And that's exactly what you need the court to do for you in the case of a disappearance. So all of these things have become standards and have been built into the treaty law and the jurisprudential law, not only of the Inter-American system, but of other systems as well. I'm sure there's a lot more that can be said, but I'll take my turn again after Elba. Thank you.
Thanks so much, Juan. And Elba, now over to you for your reflections on this.
Thank you so much, Alejandra. And it's a pleasure to be on this panel, not only because of the distinguished guests that are and speakers that are here today, but also because it's an opportunity to speak about enforced disappearances in Europe, and particularly in Chechnya. I think enforced disappearances for far too long have not been seen as a European phenomenon, and they very much are and have been. Chechnya is one example of that. so is Turkey, and now we're seeing thousands of enforced disappearances perpetrated in Ukraine. But I've been asked to speak on Khashiyev and Akayeva, and these, as Alejandra mentioned, were some of the earliest cases in the long line of judgments by the European Court, around 650 judgments, pertaining to human rights violations by Russian security forces in Chechnya and surrounding North Caucasus regions. And the vast majority of them, of these cases, do have some element of enforced disappearances. So I have tailored my comments today to the challenges that litigants faced in raising allegations of torture in enforced disappearance cases. And the broader group is known as the Khashiyev and Akayeva group of cases, and it does involve this case, but goes beyond it. There are three obstacles that I wanted to mention I thought would be interesting for the purpose of this panel today, and they all relate to the difficulty of proving cases in repressive contexts where the state actively seeks to cover the crimes it has committed, and the challenge that we face as lawyers in reflecting the victim's priorities in litigation and getting courts to focus on these priorities. Within those two categories, the first obstacle is we faced difficulty in achieving a substantive violation of the prohibition of torture vis-a-vis the disappeared person. The court required litigants to adduce appropriate evidence of the torture in each case. This is quite a departure from what Juan described the Inter-American Court was willing to look at, including evidence of systemic torture. So in our cases, what this meant is that a finding of torture where someone was disappeared was only really achieved where there was ill treatment during the abduction, where someone had been abducted alongside with the disappeared victim and later released and could be a witness, or where the victim's remains were found to have evidence of torture. This is a challenging and surprising standard to hold litigants to in cases of enforced disappearances, because we know that the aim of enforced disappearances is to veil the state's violations. And actually, in a number of cases, the court found that the government was in violation of its obligation to provide disclosure to the court. It's also a surprising standard because there was ample evidence of torture in most cases of enforced disappearances being perpetrated in Chechnya at the time. And of course, the court itself had hundreds of cases before it and was actually willing to presume a violation of Article 2 in cases of enforced disappearances in Chechnya, but was not able to do that in Article 3. The second obstacle is there is quite a high evidentiary burden on relatives to establish that they were themselves victims of torture. The court's well-established approach, which was set during the cases involving the Turkish invasion of Cyprus, was that whether a family member of a disappeared person was a victim of treatment contrary to Article 3 would depend on the existence of special factors, which gives the suffering of the applicant a dimension and character distinct from the regular emotional distress. I'm quoting the quote in the court here when I say regular emotional distress, which may be regarded as inevitably caused to relatives of victims of serious human rights violations. That meant that we had to adduce significant evidence of ill treatment or to establish Article 3 violation, including the proximity of the family tie between the litigant and the disappeared victim, the particular circumstances of that relationship, whether they were close or not, the extent to which the family member witnessed the events in question, the extent to which the family member attempted to obtain information about their disappeared person, and the way in which authorities responded to those inquiries. We were able to achieve this in a significant number of cases, but first it was a heavy burden to place on relatives, and I would say clearly a departure from international legal standards, particularly those set out in the Declaration and the Convention. But it also posed challenges with respect to certain relatives, including children and young children, who obviously were not involved in, sometimes they were born just as their parent was disappeared, and many of them were not involved in the fight to determine what happened to them. And finally, a third obstacle was that the right to know the truth and the obligation to search for disappeared victims played only a minor role in the vast majority of cases up until about 2012. Yet this was the priority of the families. That's why they brought these cases. They wanted to know what happened to their loved one, and I think that's universal. The right to truth has generally only been recognized by the European Court in a few cases. And I raise the right to truth because, of course, while it's its own right, it's intimately related to the prohibition of torture. And in enforced disappearance cases, the right to truth by the European Court was taken to form part of the state's procedural obligation under Article 2 and 3 to carry out an effective investigation that was capable of, among a number of things, establishing the truth. So that's how the court largely handled the search for victims. It was through criminal investigations, and there was very little in the judgments around the search efforts required to find the victims. It wasn't until 2012, in the leading judgment of Asakanova and others versus Russia, that the court found that it was apparent from the bulk of the judgments before it, there were around 200 at the time, that criminal investigations were entirely ineffective in establishing the truth of what happened, and resulted in a sense of acute helplessness and confusion among the relatives. And the court departed with its own practice by calling on the state to urgently create a single body in charge of searching for these victims. This case was not only monumental because the fact the court was willing to go this far, but it drastically shifted the focus of the court's implementation body, the Committee of Ministers of the Council of Europe. The Committee of Ministers started very much engaging the state on the creation of this singular mechanism focused on search, which is, of course, much more in line with international best practice than handling approximately 7,000 disappearances through individual criminal investigations. So I think what these obstacles say in terms of how to approach strategic litigation in cases of enforced disappearances and torture more broadly is the importance of establishing a pattern of violations. The continuous litigation in these cases established the systemic nature of the violations, and it supported the court and to strengthen its approach and to go further than other cases of torture that had been before it in ordering general measures, especially aimed at the search, as I said. The second takeaway, I think, is we really need to be integrating international legal standards and best practices into our litigation before different mechanisms, especially regional mechanisms. When the court was able to draw on some of these standards, I think it really shifted the discourse and the judgments from what the court would handle as more typical torture cases to the complex crime of enforced disappearances. I'll stop there unless there's any questions about that.
Thank you so much to the three of you. I'm taking a lot of reflections that come from this first question, including the importance of a victim-centered approach through litigation, which, as you said, Viviana, is really long, and also the power of victims' movements. And I think sometimes this is lost at the level of international bodies, and it's a missed opportunity, because if these fights go forward, it's because of the strength and work of these victims' movements. But also, as mentioned by Juan and Elba, the importance of establishing a pattern to balance the counter arguments of states, right, that often deny the violations when they happen in this very systemic way. And also the difficulty of proving cases in hostile environments, which is something that, again, we still see, unfortunately, today. But also sometimes the application of more strict procedural standards that sometimes are, do not meet the expectations of victims in this type of cases when they come to human rights courts and mechanisms. But for my second question, and I'm going to start now in the reverse order, so Elba will go first, Juan, and then Viviana. And what I would like to know is, because we often say strategic litigation is measured sometimes, or the success of it, by whether there was a very important legal precedent that was created, or a policy change, or a change in law. But how do we assess its real impact on the lives of those that it aims to serve? And what has been the tangible impact on the victims and communities in your 3 cases?
It's a really difficult question for me to answer because in all of our cases, there's been no implementation of these judgments, and most importantly, almost all but a couple of victims don't have any answers around what happened to their loved ones. But we have gone back to the relatives we worked with and asked this question a few times for our own purposes, but also to direct our efforts on implementation. And so I've pulled from some of those responses. The first thing I wanted to raise and that we heard was that it was really significant for people that in all the cases, the state was held responsible for the disappearances. And that's because the context that they were living in and trying to search for truth and justice in is one where the state continues to this day, so it's been more than 20 years for many of them, to deny their responsibility for the disappearance. In some cases, the victims remain on wanted lists. In other cases, the state continues to maintain that the victims fled to neighboring regions to join militia groups. And I think the court's judgment was affirmation of what these families have known all along, which is that the state disappeared their loved ones. The second outcome, which was also important and is important for our families, is that an important record was created of the disappearances, how they were initiated and perpetrated, as well as of the pattern relied on by the state. This means that in many cases, there's evidence, not all, there's evidence of who the perpetrators were. There's definitely evidence of who the federal departments that were involved were. In some cases, there is evidence of the secret detentions the victims were taken to, the mass graves where they could be. And with time passing, the significance of this record is that when one day truth and justice is possible, and it will be, there will be some concrete evidence to help with this search and this fight for truth and justice. And I think that matters to people, especially. I'm just hearing a bit of...
Yes, I think it may be one of the interpreters that has the mic on. I don't know if we can solve it, but I would say maybe continue, Elba, if you can, and we will try to fix it. Thank you.
Of course, yeah. So the significance of there being a record of evidence that could be relied on when efforts for search and for accountability are initiated. And finally, and this has been an outcome of this litigation, but I would say it's not very important for our applicants at all, is there was an award of damages and the state did pay that amount. This has been complicated because in some contexts, the state authorities have used this against the relatives. So where people have continued to search, they've been met with comments like, you received your money, what more do you need? But it is an outcome of the proceedings. With all that said, the real challenge is that, of course, the fate of the disappeared people has not been resolved in any of these cases, and the suffering of the families is immense and ongoing. So I think a takeaway is that there are measurable outcomes, and there is real value to international litigation when domestic avenues in particular are not able to produce any form of remedy. But we have to work really closely with victims so that they understand the risks, they understand the limitations, they understand what it'll require of them to participate in this type of litigation. And they can make an informed decision about where they want to allocate their resources and time and energy.
Thank you so much, Elba. And your intervention highlights the difficulty of, the fact that litigating doesn't end with a decision, right, with a judgment, but continues over many years during the implementation process. Juan, over to you.
Yes, thank you. I think the fact that the victims were so central to our pursuit in Velasquez Rodriguez is that they were already organized before these cases were brought to the Inter-American Court. And they, in fact, had been central in bringing them to the attention of the Inter-American Commission that then submitted the case to the court eventually. And in fact, when the case was before the court and we had all this evidence that we could produce, and we had to travel over several different hearings over more than a year, that of course made it necessary for us to raise some funds for this, because us lawyers basically participated pro bono, or rather, as paid by the organizations that we belong to. In my case, Human Rights Watch, but just flying people from different parts of the world to the court to provide testimony required funding, and we asked the funding sources to designate as recipients of the funding the organizations of families themselves. And they did a wonderful job in administering those funds very well and making sure that they had all they needed, but that we as litigants had all we needed as well. And so it was a very very successful effort, I would say. I don't offer it as a model because, in other circumstances, it may be, indicated that the organizations of human rights lawyers actually, get the funding themselves. But in this case, at least, it worked very well, and it allowed the organizations themselves to, figure prominently in the debates in Central America about disappearances in the context of the Central American wars, and made them an actor in that debate. I have to say, however, that we always focus on Velasquez and Rodriguez, but these were three different cases that were litigated together, and that gave rise to three different decisions. The second one is Godínez Cruz, and it was very similar to Velasquez Rodriguez on the evidence and everything else that the court says. But the third one, unfortunately, the court did not find against Honduras. It's called Fayden and Solis, Fayden Garbi and Solis Corrales. These were a couple of Costa Rican citizens who we claimed, I still claim, that they disappeared in Honduras. But admittedly, the evidence was contradictory, and it was much thinner even than the other two cases. And we were never able to establish very clearly that, in fact, they had disappeared after entering the territory of Honduras. And there had been discoveries of graves, clandestine graves, with people who looked like one of them, Mr. Fayden Garbi, but there were contradictory evidence. And the family, especially the father, who did not want to admit that his son was no longer alive, said that he didn't recognize the photograph. And so that's what I mean by contradictory evidence. And so I'm not saying that the court was right in not finding against Honduras in this case, but I am mentioning it for the fact that not everything went the way we wanted it, especially for the families. Mr. Fayden, the father of Fayden Garbi, died a few years later, and he died a broken-hearted man. And it also signifies that even when you have all these stars aligning themselves in a way that you can really, get a successful outcome, it doesn't always succeed. I think the lessons from the three cases, including this one, for the human rights movement, especially confronting disappearances, but also torture, are still very valuable. And especially where the court says that the victims are entitled to reparations, but they're also entitled to the truth and to see justice done. And governments are not allowed to negotiate that outcome. They cannot condition, for example, the delivery of reparations on the fact on the families renouncing their legitimate demand for truth and for justice. And I think that has been a lesson that, at least in Latin America, is very well established now, that reparations are one of the elements that the victims are entitled to, but it's not a menu from which states can choose. They have to comply to the best and to the largest extent of the resources, as I think that, if memory serves, the court more or less verbatim says, the states have an obligation to pursue these three avenues of redress in no matter how much time has elapsed. And that is very well established in Velasquez and in Godínez. But it's also part of the legacy of the struggle against disappearances in the continent. And I also think that the court also established certain principles of state responsibility for human rights violations that at that time were not as well established as they are now after the 2001 articles on state responsibility drafted by the International Law Commission. But in case of human rights violations of this sort, the court actually provides sort of a standard by which to judge whether the state is complying in good faith and with due diligence with these obligations. And that, I think, has helped in domestic litigation very extensively as well, because what constitutes the response that a court has to give to a request for habeas corpus? And if it's not reflected in due diligence and in good faith, then you have opened the possibilities of going to the international organs for redress. But most importantly, you also have a powerful tool in the domestic jurisdiction to have the courts do their job effectively. So I think we owe, I think Velasquez has given us these kind of tools, but most importantly, they are used by the relatives. So nowadays they demand, and in many cases successfully, not just the possibility of receiving reparations and establishing the truth and participating in litigation, but actually contributing to the design of those programs by which the government actually fulfill these obligations. Nowadays, we don't conceive of a truth commission, for example, that in the design does not include the participation, the active participation of the relatives and families of the disappeared and other human rights victims, human rights violations victims.
Thank you so much, Juan. And it's incredible to hear some of the reflections you have, and to think that so many times at redress we still see from many states the response that victims have to choose between compensation, justice, and truth. So very relevant, all of these discussions still for today, as well as many mechanisms that are being created at the moment for reparation that do not include victims in their design, including the register of damages, for example, in Ukraine, which is being discussed now, and others. So very, very important lessons from these cases which were litigated some years ago. Viviana, over to you.
No, thank you. This is a very important issue, I think, for all of us that work with human rights cases and victims and communities, to try to understand what does litigation mean for for the communities we serve and the victims we represent, and how it has impacted them individually, but also the societies in which the societies they inhabit. And so when thinking about this question, I used that technique that they have in some television shows, and I called Gisela Ortiz and asked her, who's one of the prominent sisters of one of the students that was disappeared in Cantuta, and asked her what did she think that it was the impact on her of the litigation of the case, to help me also like frame and think about this issue more broadly. And it's always incredible to hear like the wisdom behind and at the forefront of her words. And she was telling me about how having a judgment from an international court where the truth was established was so important for her and for her family, but also for the family members and for the human rights movement and for society to hear and to have that official record that set really the history right, and that it was important at the time when they got the judgment, but it was important as well in different political and social contexts later, because of the historical deniers that have plagued some of the discourses and the political discourses and the social discourses in Peru, that the judgment and was critical for her and for her family, but also for society. And she was telling me as well as how the judgment itself was a turning point. Obviously, it's not everything that they wished for in terms of, you know, changing drastically the reality of the country and ensuring fully their rights. But it was a turning point politically, socially, but also personally. And I think that, and here I go to what Cantuta has meant for justice. I think there's a couple of cases that we're litigating as a sequencing of cases. It's Barrios Altos, it's another critical case on a massacre in Peru, and Cantuta, and the sequencing of those cases in the fight against amnesties, but also in the search for truth and justice, allowed for a dismantling of the amnesty laws and the prosecution of many dozens, hundreds of persons that were involved in crimes against humanity, and the extradition of former President Fujimori, who then served time in jail for the crimes that he committed. So it was truly one of those important exercises where family members not only got a modicum of truth and justice internationally, but that impacted significantly the path for truth and justice domestically. I would add one aspect to strategic litigation and the Cantuta case and the human rights movement in Peru and in Latin America, which is that litigation itself as a process within the victims movement and the human rights movement allowed many persons, many family members, many victims to have a community to support themselves as well in situations that were really heartbreaking and moments of extreme solitude and in disheartening moments politically and socially in the country, it allowed them not only to persist, because I think they've always persisted because of love for their family members, but it allowed them to be embraced and supported in a manner that mitigated in some ways part of that enormous suffering that they were facing. And it allowed them to do it with a much broader group of people that surrounded those efforts for truth and justice. So I can think of the journalists and the artists and so many students and activists and experts that in different moments and with different manifestations of solidarity were there, even when they couldn't do more than stand in solidarity, but they were there, and that was critical for the victims of Cantuta and their family members.
Thank you. Thanks very much. And that very much goes to the concept of the holistic aspect. That is not only about submitting a legal claim, which is perfect from a technical perspective, but also the accompaniment of other strategies, advocacy, the media, and how that can also empower the movement itself. My third question goes a bit to the concept of strategic litigation today, because obviously torture is still happening in every continent of the world, despite all of these landmark cases and despite the fact that the prohibition of torture has a high standing in the legal framework, in the international framework. And on that, what makes, in your view, strategic litigation a relevant tool today? Also considering the threats that we see against regional and international human rights bodies, civil society organizations, what strategies could increase the effectiveness of and the systemic impact of strategic litigation? And what tips do you have for practitioners representing torture survivors? So it's 3 questions in one. But we have now less than 5 minutes for each of you because we want to leave some time also for question and answer. I'm going to start perhaps Juan with you this time, and then Elba and Viviana.
Thank you. Well, I have to say that I am close to retirement, so I'm not participating as much in strategic litigation recently. So I'm not in the best position to discuss the challenges that strategic litigation has today. Nevertheless, I try to keep informed and aware of developments, but particularly jurisprudential ones. And I think some things never change. And when it comes to torture and to disappearances, the main problem is documentation and evidence. And so, we're relying on the goodwill of courts to, allow them to be convinced of what things are. Can be a dangerous exercise because we can get bad law by not having the evidence well documented. And I know firsthand how difficult it is to get people to speak on the record about what happened to them or what they saw happening to others, for among other things, because of the trauma of having to relive what they experienced. But also, as has been said here already, these things carry a cost, and the cost is to life and limb and to liberty of human rights defenders everywhere. So we have to be very ethical also of letting people know what the risks are before we persuade them to come forward. We have to be very self-conscious of that, and at the same time, let them make their own decisions. And if they decide to come forward, then we have to know exactly how to document and how to store information about torture and other human rights violations, but particularly about torture, because it's always going to be difficult to prove with with forensic evidence. For example, are there still traces in the body when, in fact, the torture has happened already days or weeks and sometimes years ago? But fortunately, we also have the updated version of the Istanbul Protocol that gives us a very good landmark as to, and a very practical one, I would say, for how to document human rights violations and particularly torture. And it also gives us a very good argument for putting the burden on the states to investigate and to provide that evidence. And if you show that the state has not collected that evidence with in good faith and with due process and with due diligence, you also have an argument there. So those new instruments, legal instruments of international law, even if they're of a non-binding nature, do give us tools, and we have to use them as best we can. But always with a sense that we owe it to the victims and their families to do what they are deciding to do, but only after they know all the risks, and we tell them. And the worst risk, unfortunately, that we have to be sincere about is the risk of failure. It's the fact that we may be able and may be able to get bad law, for example, or bad decisions, and yet therefore it may still be worthwhile. Not just for personal satisfaction, but because there are so many other ways in which human rights litigation helps establish a world with truth and justice, even if we don't always get everything we want out of litigation.
Thank you so much. And I see some hearts and positive reactions when you mentioned the revised Istanbul Protocol. And I would also say the principles that are named after you, the Mendez principles, which are a really fantastic
I don't call
tool.
them that. But
we call them that for the prevention. It's so indeed many things that we can use which we didn't have a couple of decades ago. Elba, over to you.
I think it's a really important question, this question of the relevance today of strategic litigation, and not in any sense to discourage strategic litigation, but to allow us to take stock in how we're approaching it, as the question very rightly then continues, and whether we can strengthen it through our practice as litigators. In terms of its relevance, I mean, I think it was covered in the earlier question. So I'll just summarize it as it's important for victims, I think, where there's a lack of avenues domestically, especially for justice, having this international or regional court make an assessment in your case is an anchor and kind of a pillar of justice and rights at a time that can feel like those things have vanished, and there's importance in that. What that suggests, though, if we accept that that's one of the primary reasons we undertake strategic litigation, especially in contexts where implementation of cases is very difficult, is it suggests that victims and families and communities have to play a central role in setting the agenda, in determining the priorities of the litigation. And so I think as litigators, our cases, our objectives, and as human rights organizations, our long-term objectives are strengthened when we see strategic litigation as one aspect of a long-term, cohesive, and largely community-led fight for justice. And what that means is that we need to integrate our work into the work of the community and the victims to make sure we know what their priorities are and the litigation is reflecting those priorities, to make sure that the litigation is supporting the pressure the community is applying and not taking from it or undermining it in any way. And then, of course, as Juan said, to make sure it's, you know, the risks are well considered. I would also say that in cases like enforced appearance cases, for and other human rights violations, particularly in these cases, the litigation is not just an end; it's also a means. It's a process, and there's been increasing recognition with the working group on enforced appearances and the committee, and I believe the Inter-American Court as well, that enforced appearances alter the life project of a family member. Excuse me. And what becomes central to that life project is the search for a loved one. And the litigation, which can take years, sometimes even close to a decade, is a part of that life project. And how victims are treated in that process and what agency they can exert in that process matters hugely. Yet we know that litigation is so re-traumatizing in so many contexts. So I think as litigants, we have to put in the effort to make sure that we are securing people's safety, including psychological safety in litigation, and supporting them to practice their agency at all stages of legal proceedings, including in implementation.
Thank you very much, Elba. Over to Viviana.
Thank you for the question, and also thank you for the answers of the co-panelists, which were so insightful and inspiring. So I will just add a couple of points based on my experiences. Sometimes litigation is about justice and truth and equality under the law. It actually reflects a faith in the rule of law that justice should be the path for finding the truth and for repairing the wrongs. And strategic litigation doesn't have a single path. It has different paths. Sometimes it can be through criminal cases. It can be through international human rights cases in different fora. It can be through civil cases. And we've seen communities and family members in different contexts. In Argentina, and Juan has been an integral part of that. There was a time when we couldn't get criminal justice for perpetrators, and there were all these cases of litigation for the right to truth, for example. And in Brazil, there was litigation for monetary compensation when some of the criminal justice avenues were not open. So I think that strategic litigation can open different paths and spaces for discussing again what happened and what's due, not to repeat history. And that opens a path for truth and justice and rehabilitation or refuge or reparation in different contexts. And social and policy discussions about how to mitigate and eliminate torture. It allows, as we were discussing before, because of the holistic approach and the practices of the human rights movement, I think in many contexts, it allows communities to accompany, to stand in solidarity, and to diminish some of the risks of individuals and communities in litigating. So some of the tips that I would like underscore is the importance of partnerships, the importance of holistic approaches and accompaniment, they need to learn about trauma and be trauma aware and thinking about individual trauma, but also psychosocial trauma. And they need to think of strategic litigation and discussions in the current context with other media that allows us to persuade and to enlist other people in the fight against torture in the current context. And in that, I think I come from a different generation. I was, as we all say, we were born after Facebook and born before Facebook and many years before Facebook. So I think for many of us, this idea that we now need to rethink how we engage in a broader discussion and how we can use maybe litigation, but also a holistic approach to litigation to sensitize and to allow for a broader consensus on the need of societies free from torture, not only in the letter of the law, but in the practice, in the social and legal practices of countries is critical. So those would be my 5 cents.
Thank you. Thanks very much for the tips that the three of you have offered to the practitioners that are participating in the event. I have now a few questions. I'm going to read them all from the participants. And I know, Viviana, that you have to go to another event. So I will start with you and maybe take 2 minutes to respond, which is very quick, but we can try. And then Elba and Juan, and we can stay a bit longer. But the first question actually is from Viviana, from Namra Gilani. How were you able to strike the balance between bringing forward stories of disappearances and torture effectively for your clients with needing to protect them from reprisals from the state as a result? Then for everyone, from Ayisa Salim, how advocates from countries that are non-members of the Inter-American Court or the European Court and not accepted the jurisdiction of UN treaty bodies for individual cases can integrate key jurisprudence on torture from these courts into their domestic litigation and advocacy efforts? I have a question for Juan from Philippe Belizer. Juan, do you still feel that the human rights movement is challenged by an apathetic, indifferent population in the context of torture? And then there are many more questions, but we are grouping them because otherwise there is another question for Juan from Namra Gilani from Justice Project Pakistan. What are some of the best resources and from your experience, the best methodology on how to train LEA agencies on the Mendez principles? I will go to Viviana first.
Well, thank you so much. And I think that telling the stories and uncovering the truth and protection can sometimes be at odds, but can sometimes also be, can help each other. And that depends a lot in the context. So I think that in some contexts, telling the stories and shining a light on some situations can help create a level of protection of victims. In some other contexts, it can be risky. And the important thing, I think, as a litigant and as a responsible litigant is to analyze the specific risk of a specific victim individually because of her trauma or his trauma and her situation, her family situation. That comes along with issues of gender-based violence and different types of extreme trauma. But also the political situation and the social situation that can add to the vulnerability of specific victims in a specific context. And the ways of responding will depend a lot on where the person is, what are the resources. So I think that mapping and understanding where you're situated and trying to make conscious choices on how to move forward and how to mitigate risks and being resourceful and acting in solidarity is the critical piece of that. And that might include being resourceful with issues of visas or psychological support or legal representation in different fora, or appealing to interim measures or protection mechanisms of different states, or investigating different types of threats. So my main suggestion would be to be mindful and thoughtful of the context before deciding, consulting and making sure that the decision is made by the person that is should be at the center of the process, the victim, the family member, and then be extra diligent and careful in surrounding that situation and accompanying the process. Nothing is failure proof, as Juan mentioned. There's always a possibility of failure, but there's a lot that we can do to mitigate harms and to protect and support the victims that we represent. And with that, I'm sorry that I have to leave. Thank you so much for everything. Thanks for
you,
this opportunity
Viviana.
of participating.
Thanks for your time, and good luck with your next event. Thank you so much for participating. And I'm gonna now go over to Elba and then Juan for final reflections on the questions that the participants have asked.
Well, many of the questions are for you, Juan. But I will just touch on the one question, which is around how to apply international standards domestically and what to do when a state is not a member of the European Court, the Inter-American System, or the Committee Against Torture. I would say, first of all, there may be other UN treaty bodies that the state is a party to. A lot of our litigation has on these cases as well as others has been before the UN Human Rights Committee, which is tasked with implementing the ICCPR, and there are many states that are parties to that convention. So depending on the issue and the state, that could be an avenue. But of course, the prohibition on torture is a customary right of international law. And I think there's a lot of excellent writing and jurisprudence on that you can rely on in domestic advocacy and litigation, again, depending on what the context that you're working on is. I noticed there was also a question on pushbacks before the European Court, so I thought I could just touch on that briefly to say it's a really interesting issue, and I really appreciated how the question was framed. And I would echo the advice that a few of us gave a bit earlier, which is one, to do your best to draw patterns in the litigation. So that could be combining many cases together, seeking interveners, having expert reports and other reports you're relying on. And it may just mean having to bring a lot of these cases before the European Court. I would also say relying on international standards and practices. The Committee on Enforced Appearances has dedicated their first general comment to enforced appearances and migration, and it covers pushbacks. And I think it would be an excellent resource to look at. I would also suggest looking at how the European Court has handled gender-based violence, and in particular domestic violence cases, because I think in terms of looking at systemic practice and adapting the state's obligations, particularly with respect to due diligence in those cases, it's one of the areas that's a bit stronger than other similar areas.
Thank you, and thanks for addressing that question as well on pushbacks. Juan, over to you for final reflections.
First, on the question of countries that are not part of regional systems like the European, the African, and the Inter-American, Yes, I think the main problem is more jurisdictional. There's just no organs where you can go to, except in the universal system. And Elba has explained the treaty bodies and how they can be effective in this. I would also just like to add that sometimes special procedures that are not based on treaty commitments by the states can be helpful. I mean, the working group on disappearances, the working group on arbitrary detention, the special rapporteur on torture, and the special rapporteur on extrajudicial executions, all of them do excellent work. And yes, their decisions are non-binding, but on the better side, you also don't have to exhaust domestic remedies to approach them. So, and especially for urgent cases, I think special procedures can be a good resource. And even if they're non-binding, depending on how well structured and well argued their decisions may come out, they can serve a domestic purpose as well if local groups organize themselves and expand and disseminate the findings of those special procedures and of the treaty bodies in the domestic jurisdiction, and can make for effective tools. Philippe asked me about something that apparently I wrote in my book about apathetic populations. I'm not sure what I meant by it, but I certainly meant that in some circumstances, particularly when we're talking about torture of the kind of everyday kind, that populations that are, absolutely overwhelmed by the perception of criminality and insecurity. And sometimes the perceptions are real, but sometimes they're also widely exaggerated. Then they tend to have a kind of attitude towards torture that says, well, it's a dirty business, but somebody has to do it because it makes us safe. Of course, it's a very faulty reasoning. It does not make us safe. It makes us even more unsafe. But I was just trying to be descriptive there. And I certainly don't mean that in all circumstances, the population will be apathetic. It won't be. It depends on us not to let them fall into apathy. With respect to training on the principles on effective interviewing, and I did interject that I don't call them the Mendez principles, but that's not because I'm not very proud of the fact that my colleagues have decided to call it that, but mostly because it is a collective effort, and a collective effort that involves several years of discussion and a very interdisciplinary kind of approach to it. The very good news is that in addition to being adopted by two General Assembly resolutions, one General Assembly of the OAS resolution, many mentions by the European Committee on the Prevention of Torture, many mentions by other universal treaty bodies. But in addition to that, there's some beginnings of reference to them in domestic litigation as well. But most importantly, there is, and that's what I'm more familiar with at least, there's a network of research centers, mostly based in Europe, but that extend themselves elsewhere, that are very actively promoting the principles as part of the training materials for police academies and law enforcement generally, and prosecutorial offices. From what I know, at least, the important centers of that network, the network is very, as far as I understand it, includes something like 140 different research centers in different universities. But the ones that I am more familiar with and that started this are in the University of De Montfort in Leicester, United Kingdom, in Dublin, the University of Dublin, and the University of Oslo. And I think it's, they are producing materials that could serve the purposes of the question. And then there's a question about Syria. Unfortunately, I don't have an active, contact base with the developments that are happening in Syria. But I did notice that my old organization, the International Center for Transitional Justice, only a few days ago, put out some information about plans to produce Truth and Justice for the enormous human rights violations that happened in Syria. And, obviously these are first steps, and it's difficult to know how far they will go and how effective they will be. But I think it's very well worth supporting the idea, if the new government of Syria is sympathetic at least to the idea that it has responsibilities towards the victims of the war and of the human rights violations in Syria. And thank you very much again for the opportunity to participate in this webinar. It's been a fascinating experience, and all that one can expect from redress. Thank you.
Thank you, Juan. And there is Philippe Belliser who asked a question. Is asking as well how and whether it's possible to get a signed copy of your book. And I must say, I have one here in my office, and I keep it very dearly. So I understand this question, and he says that he has cited it many times when he was a graduate student and personally as a victim of torture. So
I really appreciate your words, Philippe. Again, I'm very glad to sign and dedicate a copy to you. Unfortunately, the book is out of print, and I wish I could say it's out of print because there's so much demand, but that's not the reason. It's just out of print. The Spanish version that was published 10 years later, and it's updated and expanded, published in Mexico by Fondo de Cultura Económica, is a lot easier to obtain. And I'll be glad to sign and dedicate either an English or a Spanish version. You'd have to send it to me, I suppose, but I'll be glad to return. Thank you.
Maybe that can be done separately on email. But thanks so much, Juan. Thank you, Elba, for your time and for your insightful reflections with this group. We are very happy that we were able to have this event. And we will have another one coming up very soon. So everyone will be welcome to sign up with the working group on implementation of the African Commission on Human and People's Rights. So that will be in the early fall. But for now, thank you again. Thanks all the participants for joining today. We look forward to seeing you in the future. And we will launch a poll before we close the screen. We would appreciate if participants could spend a few seconds answering the questions before they leave the webinar. But otherwise, thank you. Good afternoon to all of you. And thank you again, Elba and Juan and Viviana, for participating and sharing your knowledge with us. Thanks so much.
Thank you.
Thank you, everyone.